I want to move back to each of our speakers now. I know we've covered a lot of material today and a lot of information to get through and sift through. I want to return to each of you just for any closing remarks, maybe some key takeaways or thoughts you'd like to leave our attendees with in the few moments that we have remaining. And Mr. Johnstone, I'm going to go ahead and start with you.
Oh, thank you. And thank Dan for doing this with me. Well, a couple things. One is just to stress that trade secrets are really emerging as a very important intellectual property. I mean, they've been around in one form or another in common law, but as the states enacted statutes and the federal government enacted the federal statute, they did that for a reason, because more and more kinds of ideas, concepts, properties, things are appropriate for trade secret protection, so you should be aware of it. The other thing is that when you go to court to enforce a trade secret, the first thing that you have to do is establish that it was in fact a trade secret. So what I always tell people to kind of switch around a sports aphorism is that the best offense is a good defense. And what I mean by that is now, when you're not in a litigation, when as far as you know, no one's taking your trade secret, put things in place that make it a trade secret. So have people, stuff in your computer password protected so that only the appropriate people can get to it. Have people sign confidentiality agreements, mark things confidential. Safeguard your materials. The other thing is consult with, in the case of electronically stored information, an IT professional who can not only help you keep it secret, but can explain to a judge when you have to rush into court how things were kept, and can advise your lawyer on information that you might need to inform the court about when you seek the interim remedies that I described.
Excellent. Thank you so much. Daniel McGavick.
Thank you. Thanks, Elizabeth and John. And I would echo John's first point. I mean, we're seeing it in our practice, just much more trade secret activity in terms of enforcement and litigation, and in cases involving significant dollars. And I would advise, from a damages standpoint, that it's important to try to evaluate all potential avenues of monetary damages. As I pointed out in a couple of those cases, it seems like the plaintiff may have shortchanged itself by not considering an alternative royalty theory. So I think it makes sense to evaluate actual damages, unjust enrichment in multiple forms, as well as a reasonable royalty. And finally, I think we'll probably see the court exercising its gatekeeping role in more cases, as illustrated by the Waymo case. And the courts may take a more active role in trying to exclude damages experts, similar to what we've seen in patent cases.